Hello, everyone, and welcome to Future of Privacy Forum's panel at CPDP Latin America. We're very happy to organize this discussion today. Before introducing the topic and introducing our stellar speakers, let me first give you a disclaimer that the organizers have asked us to share. You are supposed to know that the Vargas Foundation employees and guests, and we are the guests here, will express their own opinions and not the opinions of the institution. And we also represent that we are okay with recording and with the live streaming of this session. And this is how we hope, that our ideas will be shared broadly with the data protection and privacy world. And speaking of the world, this is the topic of our panel today. We are going to discuss how several jurisdictions around the world, several data protection law jurisdictions, and a couple of jurisdictions that are currently debating the adoption of a data protection law, of a comprehensive data protection law, are dealing with artificial intelligence technologies, with machine learning, and in particular with automated decision-making, as well as other types of specific processing that might occur under the big umbrella of AI technology and algorithmic use. So to have that very important conversation at a time when several legislatures around the world are also considering adopting dedicated rules to deal with artificial intelligence systems and their impact on individual rights, on safety, on health, on societies, we've invited a stellar panel. Let me please start introducing them. And I will start with my colleague, Caterina Demetsu, who is a fellow for global privacy at the Future of Privacy Forum, and who is also just finishing her PhD thesis at the University of Nijmegen. And I hope I'm pronouncing that correctly. Welcome, Caterina. We are also very lucky to be joined by Simon Hania, who is the Senior Director and Data Protection Officer at Uber. Welcome, Simon. Thank you so much for joining us. Today with us is also Professor Laura Schertel Mendes, who is a law professor at the University of Brasilia, and it's always a pleasure to have Laura in our conversations. Welcome, Laura. And last, but by no means not least, we have today with us Eduardo Bertoni, who currently is a representative for the Regional Office for South America at the Inter-American Institute of Human Rights, and who previously served as the director of the Argentinian Data Protection Authority for many years. It's a pleasure having you today with us, Eduardo. So, to kick off the conversation, we will first hear from Caterina with a brief overview. Perhaps let's try to keep it at about 10, maximum 12 minutes of several jurisdictions around the world. She's conducting a comparative study on automated decision-making provisions under data protection law and other types of provisions in data protection legislation that we're seeing across the world, and how they might be already applicable to AI systems, to automated decision-making, to profiling, and what are the characteristics of those provisions. So Caterina, can you please share this sort of opening overview? Before you start, though, I just want to make sure I send the message that these are just preliminary findings. We are currently working to shape this study and to find the right questions to ask, the right provisions to look at. And we're very happy to hear feedback from the viewers and, of course, from our esteemed panelists.
Hello, everybody. So some practical details. You can hear me, right? And I hope that you can also see my screen that I'm sharing. Is that true? Okay, good. So thank you, Gabriela, for the introduction. My presentation has the title Automated Decision Making Around the World. And I would like to first of all begin. So Gabriela introduced the project we're working on. I would like to talk about the scope of this specific presentation. So in this first phase of the project, we have been looking in 7 different jurisdictions. We have 5 laws, and they come from the European Union, so the GDPR, from Brazil, Japan, South Korea, and South Africa. And we have also looked into 2 bills that we are expecting to see being passed in 2021, one from China and one from India. So before I start presenting the overview and these first results, I would like to clarify some points. We have used some concepts that we try to see, to find in the different jurisdictions, and I would like to give an overview on that. So first of all, we are looking into definitions on processing operation and personal data. And this is very important because in the GDPR, basically these 2 concepts define the material scope of a legislation. So for automated processing operations, if they fall under the material scope, that means that the whole set of rules of this legislation applies in the principles. So this is the reason why we look into these 2 definitions. Then we look into the principles of fairness and transparency. I would like to clarify at this point that all data protection principles are equally relevant and important when talking about ADM. We have chosen these 2 as in this first phase of the project, mainly because so there is this whole discussion around fairness, unfair algorithms, bias in algorithmic decision making, non-discrimination, non-manipulation. So we consider fairness as an important principle to begin with, and transparency is equally important because it is a precondition for many other rights to take place. So think about right to having an explanation, right to challenge a decision. So we begin from these 2 principles. And of course, then we look into specific provisions with regard to ADM or with regard to profiling. So more specific. And as you can see, we take the GDPR as our starting reference point, mainly because it's the legislation that actually sets the tone. It has quite high standards when it comes to protection against ADM. So we use this as our first point. So I'm beginning by the GDPR. Here we have on the left column the related concepts, and the right column the relevant provisions. So what we see here is that the definitions on processing operation and on personal data are very, very broad. So processing by automated means falls under the scope of this legislation. We also see that the principle of fairness is explicitly mentioned in the GDPR in Article 5. The same goes for the principle of transparency. So processing personal data needs to be processed lawfully, fairly, and in a transparent manner. With regard to transparency, we have the right of access in Article 15. And very importantly, for the ADM context, we have Articles 13, 14, and 15 that require that meaningful information about the logic involved, as well as the significance of the consequences, are communicated to the data subject. This is very important. In Article 4, the GDPR gives us a definition for profiling. So it's any form of automated decision that has as the aim to evaluate personal aspects of the data subject. And in Article 22, we have a specific provision on ADM. There is a prohibition for data subjects not to be subjected to a decision based solely on automated processing that has either legal effects or similarly significant effects. We have certain exceptions, and there are important safeguards, such as the right to human intervention, the right to express the data subject's point of view, and the right to challenge the decision. And now we move to the second jurisdiction. It's Brazil, LGPD. which is heavily inspired by the GDPR. So we see that, again, processing operation and personal data definitions are very wide, broad. So that means, as Article 3 says, that the law applies to any processing regardless of the means. That means that automated processing falls under the scope. Fairness is not explicitly mentioned under the LGPD. However, there is the observation of the good faith principle, and interestingly enough, we have a specific principle with regard to non-discrimination. So processing data should not be done for discriminatory, unlawful, or abusive purposes. And here we see that the concept of non-discrimination or for abusive purposes that leads us to think about imbalance of power or manipulation links to our understanding of fairness, at least in Europe. Then we have the principle of free access as well as the principle of transparency, and there is a specific right to access. With regard to profiling, the law says that for the purposes of this law, data that are used to form a behavioral profile are considered to be personal data. And then we do have a provision on automated decision-making in Article 20. So when decisions are made only based on automated processing that might affect the interests of the data subject, then the data subject has the right to request a review by a natural person. Also, upon request, the data controller needs to explain the criteria and the procedures that have been used. And this leads us to think about right to an explanation as we have under the GDPR. And if the controller fails to do so, then the supervisory authority needs to confirm that there is no discriminatory aspect in the way that the data have been automatically processed. Moving to Japan, we have the Act on the Protection of Personal Information, and it currently undergoes under an amendment procedure. We expect it to come into force April 1st of 2022. And importantly, we have an adequacy decision that has been adopted between the EU and Japan in 2019. With regard to processing operation, we do not have a specific definition under the APPI. However, while reading the adequacy decision of the European Commission, it actually confirms that the scope of processing operation is as wide as is required also under the GDPR. The same goes for personal data. It is a very broad definition. We do not have a principle of fairness. However, according to the adequacy decision, it is through the purpose limitation principle that the Japanese system ensures lawfulness as well as fairness. Transparency, we see it into Articles 18 and 28. So there is a right to access. There is no provision with regard to profiling, nor on ADM. However, again, the adequacy decision clarifies the point and actually says that this ADM processing is addressed in certain sectoral rules applicable in Japan. So not in the general data protection law. And the EDPB, on its opinion on the adequacy decision, invites the Commission to monitor these cases, so to keep an eye. Now we move to South Korea. We have the Personal Information Protection Act, which is in force since August 2020. It also undergoes amendments, so we are still waiting for the final draft. And in June 2021, the Commission launched the process for an adequacy decision to be adopted with South Korea. Looking at the definitions, processing, operation, and personal data are very broad. There is explicit mention to the principle of fairness in Article 3. So personal data should be collected based on lawfully and fairly. There is also the principle of transparency. So the data controller needs to have in place a public privacy policy and guarantee the data subject's rights, such as the right of access. And I quote here the relevant articles. There is no specific provision for profiling but also there is no specific provision for ADM. However, there is a definition with regard to visual data processing devices, and this is important for the facial recognition debate that is ongoing. So we have a definition. It is with regard to devices that are installed at a certain place to take pictures of persons or images or transmit such pictures. And the law in Article 25 actually limits installation of these devices. So basically, there is a prohibition to install such devices in open places unless this is provided for by law, or it's for the purposes of prevention, investigation of crime, safety purposes, traffic control, or analysis of traffic information. And when that happens, safeguards need to be in place, such as transparency, purpose limitation, data security. With regard to the installation of these devices in places that are likely to noticeably threaten individual privacy, and some of the examples given are like bathroom, restroom, sauna, or a dressing room used by multiple persons, then again, it's not allowed unless there is a very specific exception, as is the case for mental health care centers. South Africa, we have the Protection of Personal Information Act. It is fully applicable since 2 weeks. And here, again, we have very broad definitions. So automatic processing falls under the POPIA. And there is no explicit reference to fairness. However, personal information must be processed lawfully and in a reasonable manner. There is a principle of openness and, of course, a right of access. And then, with regard to ADM, there is a right for data subjects not to be subjected to decisions that are based solely on automated processing and have the intention to provide a profile. This is repeated in Section 71 of the law. When the decision is based solely on automated processing, it has the intention to profile, and it has legal consequences or affects data subjects to a substantial degree, then it's prohibited unless it is required by contract or by law. And again, the law provides safeguards such as data subject needs to be able to make representations about the decision, and also the controller needs to provide sufficient information about the underlying logic so that the data subject can make these representations. And now I'm going to the bills. First bill is China, the PIPL. We're in the second draft, which is expected to become law in 2021. Again, very wide, broad definitions for processing operation and personal data. We do not have a principle of fairness. However, we have a principle of sincerity, and it is prohibited, according to Article 5, to handle personal information in misleading, swindling, coercive, or such other ways. And this makes us think about the concept of fairness. With regard to transparency, we have the principle of openness as well as of transparency and multiple rights and obligations. Article 48 specifically talks about the right to request the personal information handlers to explain the rules of the handling, and handling means processing. With regard to automated decision-making, there is a definition in the law. And according to Article 25, transparency of the decision-making process, as well as fairness and the reasonableness of the result of this decision-making process need to be guaranteed. For those who conduct commercial sales, the law requires that there is an option not to target individual characteristics, and that there is a method in place for the individuals to refuse. With regard to decisions that have a major influence on the rights and interests of the individual, then the individual has a right to an explanation and a right to refuse that personal information handlers make decisions solely based on ADM. And then relevant article is Article 27, again, relevant for the facial recognition debate. So basically, it prohibits the installation of image collection unless it's for purposes of public security or to observe relevant state regulations. And there should be clear indication so that individuals know that they are installed, and it should be used only for specific purposes for public security. And I would like to end by presenting the Bill of India, which is the Personal Data Protection Bill, and is also expected to pass by the end of 2021. We have a broad definition for operation. Again, automated processing falls under this definition and the material scope. With regard to personal data, the interesting part is that the law refers to inferences that can be drawn from the processing of data for the purpose of profiling. Then we have explicit mention to the principle of fairness. There are relevant articles that guarantee transparency. So, for example, right to confirmation and access. With regard to Article 3, profiling means any form of processing that analyzes or predicts aspects. So we have a definition for profiling. And we also have a definition for automated means, but we do not have a specific ADM provision. So this was the last jurisdiction. I would like to finish my talk. So as Gabriela said, of course, it's an ongoing project. We still want to look into quite more jurisdictions and expand the list. For the time being, we see that, of course, not all laws have specific ADM provisions. So 4 out of 7 have. 3 do not have. The same goes for profiling. Interesting to see that there are 2 laws that have specific provision for facial recognition. And the very, this primary conclusion would be that even if there is no specific provision on ADM, these laws do apply when automated processing operations take place. And this is by virtue of their broad material scope when looking into the definitions of operation and personal data. With that, I would like to close and thank you for your attention.
Thank you very much, Katerina. That was very comprehensive indeed. And I will immediately go to our speakers now for their reactions to what we just heard, and then for more nuance to some of the conversation here. Let me start with Simon. Simon, we have already seen some of the GDPR provisions actually being applied in courts in very recent months, in the past year or so as well. What have those provisions been applied to automated decision making, and what are some of the first lessons to learn from the cases that we've seen?
Yeah, thank you, Gabriela, and great pleasure to be here, as well as thanks for the very comprehensive overview. That's really helpful. What I want to do is share a bit of the insights I gained from a few court cases, but also a judgment of DPAs. And I'll be doing that out of the perspective of a data protection officer in the sense of GDPR, so with a relatively independent view that I'm allowed to take. So I'll be speaking for myself, so to speak. And I'm also looking at this not only from a GDPR perspective, but also from other territories in which DPO type roles have been enacted. And that's why I'm also so interested to reconcile all of these slightly different legislative views. But now going to what it means in practice. So I want to share with you some thoughts on 3 cases, 3 companies that recently have been subject to legal action, either in the court or with a DPA. And these companies are Uber, which I in a way represent, Ola, which is an Indian ride-hailing company, and Fodinho in Italy, which is a subsidiary of Glovo, a global food delivery company. So let's first start with the case with Uber. That was a case which was in the courts. It was not going to the Dutch Data Protection Authority or any other data protection authority. And interestingly, and that's common with all of these cases, these are the first cases which in which automated decision-making has been looked at, and they all are in employment or assignment of jobs space. So while people may have thought EdTech is a prime candidate for these kinds of cases, or autonomous vehicles, or health, no, that's not happening. It's happening in the context of employment. And that's, I think, the first significant thing to notice. So what happened in this case with Uber? So as you probably are aware, Uber connects riders, so those who want to take a trip, with drivers, those that can offer a trip. That's done in a dynamic fashion, and drivers and riders are matched together in an automated fashion. And that was put forward to the courts because there were several drivers who were convinced that Uber was also using, in an illegitimate way, information about their behavior, their ratings, their driving behavior, in order to match riders with drivers and potentially penalize the bad actors in doing so. That's one element. And the other element is that sometimes drivers are deactivated, so kicked off the platform for reasons of misconduct or violations of anti-fraud policies. And the allegations made were that this was a fully automated process. So 2 cases of automated decision making. So to cut a long story short, the judges in this case, based on all the information presented to them, arrived at the conclusion that in the first one, the matching, indeed, there is automated decision making under Article 22, that indeed there is solely automated decision making. The dispatching and connecting riders to drivers does not have any human intervention, because that's the essence of such a platform, that it's done automatically. But that, and that's the second test for automated decision making under Article 22 of GDPR. The second test is that it has a legal or similarly significant effect. And the judges, after consideration, arrived at the conclusion, by taking the guidance of the European Data Protection Board into consideration, that this matching does not constitute a legal or similarly significant effect. So that was an important conclusion. So the effect is not legal or not significant enough, because offering a trip still allows the driver to accept it or not manually, but also the effects of not being offered a trip, or the amount of money involved is such that it would not be significant. So that's where actually Article 22 was defined as being not applicable. The next case, which was on the deactivation, the judge, after again having been presented with all of the information, arrived at the conclusion that what Uber put forward, that there indeed could be an automated signal of potential fraudulent behavior or misconduct. I won't go into the details of the examples here, but in essence, it could be financial fraud or safety-related issues. And Uber was able to demonstrate that in all of those cases, indeed, a human intervention happens before the actual deactivation is conducted. So while this could be seen as solely automated signaling or a decision, the final decision is always made by a human, which actually goes beyond what Article 22 requires, because Article 22 does allow fully automated decision making as long as human intervention rights can be honored, which could also be after the fact, but Uber is doing that before the deactivation. So this was where the judge concluded Article 22, to the extent applicable, is adhered to. Or you could also argue it was not solely automated decision making. It was automated decision making with a legal effect, but not solely automated. Okay, those are the 2 Uber examples. Over to the Ola example. Ola is also a ride-hailing company who has now started in Europe, or I should say in the UK. And what they do is fairly similar to what Uber is doing. But what they did is, rather than deactivating drivers before going into that more severe legal effect, they already penalize drivers by withholding money from their fares, like in a a penalty. And that's where the judge said that is a legal or similarly significant effect, and you need to honor what's in Article 22, which relates to proper explanation, fairness, and potential human intervention. So Ola was ordered to rectify that. So those are the two cases in the ride-hailing business. Now we move over to the other one, the Foodinho case. And this is a company which has couriers or riders, as they call them, who deliver food. And what they need to do before being able to pick up trips and food and deliver it, they need to subscribe or to a delivery slot. So when they have a delivery slot, they are assigned, for instance, 2 hours of work and get paid for 2 hours and then get delivery orders. Now, Foodinho, as the Italian DPA uncovered and published, so that's why I can publicly talk about it, had a system which they called Jarvis, so they named their algorithms Jarvis, which, aside from presenting the couriers with potential slots, also assigns them based on a form of excellence score. So how good are these couriers in terms of being punctual, in terms of having high ratings, and so on. Now, having investigated, the Italian DPA, aside from a whole slew of other elements, arrived at the conclusion that Foodinho was doing this this was solely automated decision making, with a legal or similarly significant effect, because it deprives or grants people effectively working time, so they will get paid 2 hours if they sign up for 2 hours. And that while it is under the exemption in Article 22 of necessary for the contract, which is part of this, Foodinho also did not grant sufficient explanation as to how this works, or the right, again, for human intervention to at least ask why someone is not being put into a certain shift. But also, and this I think is even more relevant, they also arrived at the conclusion that by using these personalized performance metrics, the principle of fairness might have been violated, but also an accuracy principle, because Foodinho was not able to clearly demonstrate that the profiling they did was sufficiently accurate to have the effect it causes, the fact that people are not being granted a shift and hence being deprived from income. So that was a very relevant. This one was conducted by the Italian DPA, in conjunction with the Spanish DPA, because Foodinho is a global subsidiary who is headquartered in Spain. So this is also a case which went through I think, but I'm not entirely sure, a limited version of the GDPR one-stop shop, and therefore gained visibility within the EDPB. So there is a bit more substance, I would say, behind this outcome. Foodinho was ordered to correct their practices within 90 days. Now, it's also relevant to notice that all of these cases, if you look carefully at when they started, they all date back already from 2019, which suggests to me that there may be a lot of other cases still under the radar, underwater, which will present themselves going forward. So that's about these 4 cases. Very, very nuanced, specific reasoning conducted by courts and data protection authorities. Thank you.
Wow, Simon, thank you so much for that. It's really fascinating to see these provisions finally coming into life, and to see exactly how they manifest in practice, because we had some of them, under the Directive 95/46, the predecessor of the GDPR as well. But we haven't seen them a lot, I would say, manifesting. So this is so interesting to see now that courts and the DPAs as well are starting to sort of put flesh on the skeleton of this provision, and they are starting to look exactly at what constitutes a significant effect over the individual and their rights, and exactly how this transparency into how algorithms work is supposed to be given to individuals. I would like to go now to Laura. Laura, we are seeing in the LGPD some of the same concepts. So we are seeing an automated decision-making provision as well, but there are nuances there. And there are some differences than how the GDPR is dealing with it. Can you please tell us your view on how the provisions in the LGPD, the automated decision-making provision, and maybe other provisions that you see relevant to ADM are present, right, in the LGPD?
Okay, thank you so much, Gabriela. Good afternoon, everyone. Thank you for this kind invitation to participate in such an interesting panel with Gabriela, Catarina, Eduardo, and Simon. In Brazil, we have recently approved a Data Protection Act. We call it Lei Geral de Proteção de Dados, LGPD, as Catarina has already presented. And the law entered into force last year. The LGPD regulates automated decision-making processes with some similarities with the GDPR, as Gabriela stated already, but there are also interesting particularities that I would like to highlight. Some of the provisions of the Act are directly applicable to automated decisions, such as Article 20. Yeah? And Article 20 states, the data subject has the right to request review of decisions taken solely on the basis of automated processing of personal data that affects his or her interests, including decisions intended to define her or his personal, professional, consumer, or credit profile or aspects of his or her personality. And whenever requested to do so, the controller shall provide clear and adequate information regarding the criteria and procedures used for an automated decision subject to commercial and industrial secrecy. So I understand, such as Catarina stated, that we have an explanation, right, such as the one established in the GDPR. And paragraph 2 states that if there is no offer of information as provided in paragraph 1, based on commercial and industrial secrecy, the national authority may carry out an audit to verify discriminatory aspects in automated processing of personal data. So we have as well an editory process that is possible if there are claims of discrimination, that the person was discriminated. As we can see from these provisions, decisions made based on solely automated processing that somehow affect individuals' interests may be subject to review. What is not yet clear, however, is what the definition for solely automated will be, as well as the degree of review that will be required for the provision to be considered fulfilled. It is also worth mentioning that originally Article 20 stated that such review had to be carried out by a human, but that provision was later excluded from the law. In that context, one must inquire what kind of review will suffice to fulfill this requirement. It is equally unclear whether decisions based primarily, but not only, on automated means will also be somehow subjected to the legislation, and if so, how. Furthermore, the law establishes a row of principles which can directly influence the debate regarding ADM, such as the purpose limitation principle, necessity, data quality, transparency, non-discrimination, and accountability. And no doubt that a very important principle, such as the one mentioned by Catarina, directly applicable to ADM, is the non-discrimination principle. Although it is not clear what unlawful or abusive discrimination means for the purposes of the Act, it is clear that the law accepts statistical discrimination, but it remains to be seen, however, how the authorities and the judiciary will reconcile these ideas and applying these rules to ADMs and to credit scoring in general. Moreover, I would like to highlight a very interesting rule that we have in the LGPD, and that is established in Article 21. It is a rule regarding discrimination practices as well, and which states that personal data cannot be used regarding the exercise of the rights of the data subject. So I will read this disposition. Article 21. Personal data concerning the regular exercise of rights by the data subject cannot be used to her or his detriment. I think this provision has a great potential regarding discrimination. Germany has experienced that credit bureaus may have economic incentives to consider the exercise of a person's right as a negative criterion. It is known that credit bureaus negatively assess information regarding the exercise of the right to access one's own credit score. While in the view of the data subject, she or he is only exercising her right of access from the point of view of the credit bureau, it is assumed that those who demand information about their creditworthiness have frequently or more frequently than normal have an increased risk of default. So I think this is a rule that we have in the LGPD. It's really interesting, but of course the exact I think we will have to develop it how it will apply to ADMs and to algorithms in general. And so if to summarize the rules we have regarding ADMs, we have an explanation right, we have the possibility to audit the system. What is not clear if the law requires human intervention for reviewing for a process of reviewing ADMs. I think we must worry about discrimination with regard to the due process of the decision making when the individual is not given the opportunity to present the details of his or her case. So when this normally complex personal decision-making process is replaced by automated data processing, is essential to guarantee the possibility of participation of the affected person. I think there are strong arguments to understand the necessity of this human revision under Brazilian law and under the Brazilian Constitution, especially since our Supreme Court has recognized last year the fundamental right on data protection. So it is possible that this debate on rights regarding ADMs occurs and takes place in the future also in a constitutional level. So I think, Gabriela, this is an overview and with some nuances, and I hope I can participate in this dialogue and in this debate after the other panels. Thank you very much.
Thank you very much, Laura. This has been indeed enlightening, and it's so interesting for me to see that Brazil has thought it's important to deal with these issues of non-discrimination as well in automated decision making. And while taking some inspiration from the data protection framework in Europe, there are certainly nuances that will continue to be shaped by perhaps constitutional court, constitutional review intervention, and I'm sure by the ANPD, the Data Protection Authority in Brazil, when it will start looking at these provisions as well. And Laura, I know that you will have to leave a bit sooner, so please, when the time comes, just don't worry, and we are very grateful you shared your thoughts with us on this important matter. Now I would like to move to Eduardo. We ask Eduardo to zoom out a bit. So we looked at Brazil, but there are many other jurisdictions in South America that have data protection law and that have provisions which already apply to some of this type of processing. Can you give us your thoughts about how these provisions are already applicable to automated decision making? Do you see the need for some improvements there? And then if I may also invite you to look broader at the human rights protection system in South America, and how do you see it as being already ready to deal with AI and automated decision making?
Okay, there are very interesting questions and broader questions as well. First of all, thanks a lot for the invitation to this panel. I am enjoying a lot the presentation of my colleagues here today. There are some things that I would like to start saying for the sake of clarification. When we are talking about Latin America, some people think that Latin America is a very homogeneous region, and it is not. It is not in this area, and it is not in other areas as well. We just heard Laura, for example, and the example of Brazil that just passed data protection regulation and data protection law. But this is not the case in all of the Latin American countries. Argentina, for example, has a data protection law that is coming from the year 2000. Chile is fighting for having a data protection law for many years, and they do not have a specific data protection law today. There are other countries that are, discussing or passing data protection legislation, like Ecuador or Peru, trying to modernize their data protection regulations, Colombia as well. So it is very difficult to give a very general view of this matter. But having said that, let me start saying a couple of things that I think that are useful to understand a little bit more what's going on in the region. And I already said, many countries are trying to modernize their data protection legislation. First of all, in terms of the human rights framework, this is for all the Latin American countries. All Latin American countries are state parties of the Inter-American Convention of Human Rights, of the American Convention on Human Rights. And though personal data or data privacy is not specifically included in the treaty, it is in the treaty included the right to intimacy, the right to privacy, and these kind of things. And we can, extrapolate, we can make good interpretations about the protection of data privacy in the regions coming from this regional treaty, the American Convention on Human Rights. Having said that, there is not a specific case decided by the Inter-American Court of Human Rights that touch the case of personal data, protection of personal data, and more specifically, automated decisions. So we don't have any kind of interpretation coming from the Inter-American Court of Human Rights on those issues. The other general thing that I would like to mention here is that there are some countries in Latin America that are state party of the Convention 108, and some others are already signed the Convention 108 plus. Not many. Argentina, Uruguay, and Mexico are state parties of the Convention 108. Argentina and Uruguay signed the Convention 108 plus, but there is no ratification yet of the Convention 108. So it this is important because this could be some sort of guidelines for the rest of the region or for the region in terms of how to deal with automated decisions and the protection of personal data. Third general aspect is how influence or how big was the influence of the GDPR in Latin America. Many countries are trying to get an adequacy decision. Up to date, only Argentina and Uruguay are considered adequate countries for the European Union. Those are not new decisions, actually are old decisions. Argentina, for example, is an adequate country since the year 2003. And now those countries are under revision because of the new guidelines in Europe, the GDPR. So it is important to mention that, because if countries in Latin America wants to be considered adequate countries for the EU, they have to do something in terms of regulation of automated decisions and the protection of personal data. So what I mentioned up to now is in some ways something related to hard law treaties, like the Convention 108, the American Convention on Human Rights, or political decisions changing the regulations in Latin America to be considered adequate countries for the European Union. But there is something more specific that I would like to mention here today, which is what the Ibero-American Network of the Data Protection the Ibero-American Network of Data Protection, which is the only network that we have in Latin America that join data protection authorities plus other authorities and officials working on data protection for many years now. And the Ibero-American Network issued in the year 2017 what we call the Ibero-American Standards for Data Protection. And specifically there, yes, we mentioned the automated decisions. You can go to the Ibero-American Standards and you can go to Article 29. And specifically, Article 29 title says right not to be the subject of automated decisions. Okay, and Article 29, paragraph 1 says the data subject will have the right not to be the subject of decisions that produce legal effects or significantly affect him or her that are based solely on automated processing aimed at evaluating, without human intervention, certain personal aspects of the same, or analyzing or predicting, in particular, its professional performance, financial situation, health status, sexual preference, reliability, or behavior. You can read more of the Article 29, but at that time we included, and I say we because at that time I was part of the Ibero-American Network as the Data Protection Authority in Argentina. We included a provision that is very similar of the GDPR, of what we have in the GDPR. Of course, that the Ibero-American standards are not hard law. They are only guidelines for the regions, but are important guidelines that many jurisdictions are taking into account when they are thinking in having new legislation or modernizing the legislation. There is another document that I think that it is important, thinking in artificial intelligence, for example, which in general involve automated decisions, that is coming again from the Ibero-American Network, which is what we call the General Recommendations for Processing of Personal Data in Artificial Intelligence. This is another document that it is included you can read in the website of the network, and For the sake of this conversation, just let me mention what are the recommendations that the network included in that document. The recommendations are: one, something very obvious, comply with local regulation on the processing of personal data. Two, conduct a privacy impact assessment. Three, embedded privacy, ethic, and security by design and by default. 4, materializing the principle of accountability. 5, design appropriate governance structures in organizations developing artificial intelligence products. 6, adopt measures to guarantee the observance of data protection principles. 7, respect the holder's right and implement effective mechanisms for exercise of those rights. And 8, ensure data quality. 9, use anonymization tools. And 10, increase holders' trust and transparency. Again, this is different of the standards. These are guidelines that were issued by the Ibero-American Network, but are also important for the jurisdiction that are thinking, for example, in regulation of artificial intelligence. Let me move to what's going on in one country. For example, in the case of Argentina, but we can also think in a similar way to other countries as well. In some countries, including in Argentina, you don't have in the domestic legislation something very specific on automated decision and the protection of personal data. But what we did in Argentina 2 years ago, I guess, was to do some sort of interpretation of the domestic legislation by a resolution that we passed 2 years ago, and specifically in that resolution we said, again, it is not any. We didn't do any change in Argentine law because we couldn't. What we did is the interpretation of the current legislation, which is the way that many jurisdictions can do when we are entering in this field: artificial intelligence, automated decisions, and so on. So what we said specifically in a resolution that in the event that the person responsible for the database makes decisions based solely on the automated processing of data that produce harmful legal effects for the data subject or significantly affect him in a negative way, the data subject will have the right to request the person responsible for the database an explanation of the logic applied in that decision in accordance with Article 15, subsection 1 of the law. So what we did there was to include this idea that is coming from different standards, that if an automatic decisions harm you, affect you significantly, you always have the possibility to have some sort of human intervention. And I mentioned also about the importance for Latin America and the region as a whole to work on a more, I would say, modern legislation. In the year 2017, the Data Protection Authority in Argentina proposed a new law. The draft was sent to the Congress in Argentina, but finally the Congress didn't discuss it, and the process is an ongoing process. So I'm not saying here that Argentina changed the law. However, I would like to mention to you that in the case of Argentina, that draft included a specific provision on automated decision. It was the Article 32. You can check all the draft in the website of the Data Protection Authority in Argentina. And Article 32 says automated personal evaluation. The data subject has the right to object sorry, I am trying to translate. The owner of the data subject has the right to object to be the subject of a decision based solely on automatic data processing, including the profiling, which produce harmful legal effects or significant effects in a negative form. Again, here the idea was to give the data subject a right to oppose data processing that is an automated data processing that do not or does not involve a human intervention. So it's again, Gabriela, it's difficult to mention all the situations in Latin America as a whole for the reasons that I explained before, but those are some of the examples of what's going on in Latin America. To finish with my presentation, the Inter-American Juridical Committee, which is one of the bodies of the Organization of American States, just passed a set of principles for personal data protection, and it is not included there something very specific on this area, but again, doing some sort of interpretation, I would say that the idea is what I explained here for the countries in Latin America, not to allow or give the data subject the possibility to request explanations, give the data subject the possibility to oppose the data processing in some situations, but always when that data processing or when that processing could affect significantly or harm significantly the data subject. I remember discussions saying, well, okay, this is interesting, but what means significantly? How we are going to consider that there is an important harm or a significant harm to the person, the personality of the person, to the data subject. Well, that is difficult, and I always say the same. Well, at the end, you will need someone who evaluate, the damage. Could be a regulator or it could be a judge. But this is the broader idea in Latin America that is coming from this Ibero-American standard. Thank you.
Thank you so much, Eduardo. That was very, very interesting and a comprehensive view of what's happening there. And it's interesting that you mentioned, one of the debates around the principles proposed being the quantification of the effect of automated decision-making on the individual. And this is where, Simon, it was so important to hear from you at the beginning with the cases that are already being decided in Europe. We saw that in the Uber case, the judge found all of the conditions were met, with the exception of the significant or legal effect on the individual. And then in the other case, in Ola, the judge was able to identify a significant effect. Now, with the exception of this very specific details in the provisions related to automated decision making, and we have already discussed, human intervention, significant effect on the individual, review that might happen afterwards as well. What are the other provisions from the GDPR that you think are particularly relevant for this debate? What are you looking at in particular right now in other provisions?
Well, I would say that many regulations in Latin America has as the most important or the unique legal base for doing data processing the consent of the data subject. In the GDPR, you have more than that. You have many other legal bases to process personal data. And I think that those provisions are the provisions that we need to look closely. Not only for this area, automatic decisions and artificial intelligence, but also for other areas that are very important for us, which is transborder data flow, for example. The requirement of consent in a very, I would say, old-fashioned way, it could be a problem for the development of technology and development of this new era. And there are other there are other legal bases to do these kind of things that are perfectly legal and that also protect the data subject. So I would say that, Gabriela, that there are one of the things that we need to see closely is how we are going to do interpretation of data processing, what are going to be the legal basis for data processing, and if we are going to detach a little bit for the strong view that the only possibility to do data processing is consent. I'm not saying that consent is not important. I'm not saying that we need to abandon the idea of consent, but I'm only saying that it could not be the only legal basis for data processing. Including in the draft that we worked in Argentina, we also included some sort of interpretation or some sort of guidelines on how we are going to do interpretation of consent in specific or in some particular situations that involved, platforms or that some people didn't like when we included that. Some people say that we are moving from explicit consent to some sort of implicit consent. It's not exactly like that, but that was the direction. It's trying to do some sort of flexibility, because if we are still thinking in consent, as I said, in the old-fashioned way, I mean, technology is, or the way that we are working today, it's almost impossible to think about cookies, think about a lot of different things.
Thank you. Simon, so besides consent, we already saw that in the judgments you mentioned, and actually in the Data Protection Authority's decision from Italy, there were specific principles that were of relevance. Can you please tell us a bit about those principles?
Yeah. Before I go in there, I think it's also important that we stop presuming that humans can take decisions better always than machines can. That's if we make a shift, are so focused on automated decision making, I think it's important to consider the broader topic of fairness and accuracy, which are exactly principles in GDPR, but also in a way in LGPD and other laws, which need to be adhered to also when humans take those decisions. But we should also not focus completely the world through a data protection lens, as was already expressed. This is about other fundamental rights, and that's why it's also so fascinating to see that just by applying labor law, you can also arrive at a requirement of non-discrimination, and then it doesn't matter whether the discrimination is performed by humans or by machines, it's still discrimination. So that's why when data is at stake, I think it's very important to look at these principles of, for instance, GDPR, which are about fairness and accuracy. And in particular, accuracy is often overlooked. If you have inaccurate data, it's very hard to arrive at the proper decisions. But I also think that a principle, and I don't know whether you can really read it into GDPR, but to also have the information available that is fit for purpose. And that means that you should not only limit the data to make the decision, but also allow the human decision making or the machine to incorporate additional data which could be presented by the data subject of which the decision was made to re-evaluate. So the principles of fairness, accuracy, but also data minimization to take that as data right sizing rather than as purely minimizing are important elements to consider in my view, without or even before you arrive at the nitty-gritties of these articles that have been enshrined with respect to ADM. It always applies, and humans can be as discriminatory as machines can, and maybe with machines it's easier to detect because they tend to be consistent in their discrimination, whereas humans may not be, and you still need to look into that as well in my view. So there's really more to it than just the ADM articles.
Thank you so much for that perspective, Simon. I have to admit, this is also my view, and this is one of the reasons that Katerina, myself, and our colleagues from the team, Sebastião, Hunter, Lee, we are looking at several provisions, and this is actually very helpful for our analysis. I have seen in the AI regulation that's being proposed by the European Commission, and we are not going to talk about it now because that would be a completely different subject, and we'd have a lot of time to spend to talk about that one. But accuracy and data quality, in fact, is one of the provisions that's being proposed in that regulation as well. And I would say, to end our conversation here, I would like to now close the circle and give the ball back to Katerina. Katerina, can you tell us just a bit of how this AI regulation draft proposal has been met in Brussels? What are just one or two of the key debates around it? And I'm asking that because I'm curious, is there a gap that a targeted regulation towards AI should fill, a gap in legislation? We are seeing how data protection law actually already has a lot of rules and principles that apply to automated decision-making, to machine learning, and to this processing in this universe. So to close the conversation, looking a bit towards the future, what are we seeing in that draft proposal, and what are your thoughts about any particular gap that it could address, or maybe perhaps it's not even necessary to address some of the gaps?
Thank you for the question. I think it's very relevant and very timely. So currently, in the EU, we have this new AI Act, the proposed AI Act. There is a heated debate around it. So many conferences, seminars, legal scholars debating about it. I think that you touched upon a very important point. And I also believe that this is, so after the first shock of seeing this new law, which is quite new in many senses, also for people who have been working on the GDPR. So the conversation, I think, and the point that is quite highlighted recently is exactly the role that this act is called to play. So I think that before discussing anything else, we need to be aware that in Europe, we have laws already here, and we have them for many years. There is a lot of case law interpreting provisions. Of course, the GDPR is the most prominent example, but we should also think of competition law, employment law. So as Simon said, these three decisions that he described were in the employment context. So we need to have in mind that this act comes into play when in a structure of laws that are already here. So So this is the first thing that we should think of. And then looking at the AI Act, the question that needs to be asked is, okay, what is the gap that this act comes to fill in? And this is exactly what you said. What is the role that we want it to play? So I think that first of all, for example, I'm focusing on the GDPR because it's my area of expertise. So the GDPR has a very robust system of algorithmic accountability. It has principles in place. It has processes that have a precautionary approach, such as the data protection impact assessment, which is a very important process, rights and obligations. So we are covered, we are protected. So our rights are protected, and we need to look into that. Now, the AI Act belongs to a family of laws which is of different nature. So it belongs to this new legislative framework. And in this family of laws, we also see other instruments such as toys, machinery, medical devices. I think that the added value and what we should focus on is that these laws target to safety. So they want to bring in the internal market safe products and services. And this is very important because having a safe AI system, secure AI systems is a prerequisite if we want fundamental rights to also be protected. So I think that when looking into this act, which is quite new, we should have in mind that it is a block, a piece of a puzzle, and we need to find its place in this puzzle without disregarding the other laws that are already here.
Thank you so much for those thoughts, Caterina. And thank you, Simon. Thank you, Eduardo. Thank you, Laura. This has been a wonderful conversation, and I hope it's just sort of the first of others to come, because it's very important to be able to properly map all of these provisions and how they fit in place and how we build this puzzle of protections for individuals in the age of AI and machine learning and automated decision making. Again, thank you, and thank you to the organizers for putting together a fabulous first edition of CPDP in Latin America. Thank you all.
Thank you very much.
Thank you.